Ramuno, you may proceed when you're ready.
Thank you, Your Honor. Sergeant, would you please introduce yourself to the jury?
Yes, my name is Sergeant Liz Lenzen with the Tempe Police Department.
And Sergeant, how long have you been employed with the Tempe Police Department?
Approximately 18.5 years.
And what is your current assignment?
I'm a patrol sergeant.
Okay, and what does that mean?
I supervise a squad or squads of individuals that patrol our city.
And I'm going to draw your attention back to December of 2009. Was that your position at that time as well?
Yes, ma'am.
All right. And specifically, do you recall working the date of December 27th, 2009?
I do.
Okay, and can you please tell us that day, did you become involved in the investigation of a missing baby by the name of Gabriel Johnson?
I did.
And what was your involvement in that case initially?
I was one of the first responders to check the trailer located on South Priest Drive for the child, along with Officer Pena.
All right, and was that the trailer that was purported to be the trailer of Elizabeth Johnson?
Yes, ma'am.
And the home of the baby Gabriel Johnson?
Yes.
All right, now can you recall what happened when you went out to that location?
There was no one home. Initially, the trailer was locked, and the neighbors couldn't provide a whole lot of information to us.
So what did you do at that point?
I asked Officer Snell, who was out with Logan McQueary, to get more information. We needed to find out what we were looking for at the trailer and the circumstances behind that investigation.
And did you receive the information that you requested?
Yes.
And what did you do at that time?
I notified our criminal investigation supervisor and informed them that we have a missing child. One of the things I did do was request Elizabeth Johnson's phone number, which was a 210 number, San Antonio exchange number. That we got that from Mr. McQueary, and we proceeded to try to call her on the phone.
Okay, I'm going to back up just a bit so this is clear. When you first went out to that home in the city of Tempe, your information was that this was a missing child or custody dispute?
Yes.
Okay, and was it at the time that you spoke with Officer Snell that you realized the situation was more dire?
Yes.
Okay, and what information did you receive that led you to believe that?
He informed me that he listened to a tape recording that indicated that she may have harmed the child.
And when you say he, are you referring to Officer Snell?
Yes.
And when you say she, are you referring to Elizabeth Johnson?
Yes.
So at that point, what did you do?
We did a number of things, but my initial what I initially did was to call Elizabeth Johnson on the phone number provided, and I did speak with her. And
before you get into that, just so our timeline is clear, had you seen the roommate at this point yet?
yes, an older gentleman showed up, and Officer Pena interviewed him.
And was that somebody by the name of Malcolm Phipps?
It sounds familiar.
Malcolm Phipps?
That sounds familiar, yes.
So you yourself, did you speak with Mr. Phipps, or was that solely Officer Pena's duty?
Officer Pena.
All right. While he was speaking with Mr. Phipps, what were you doing?
I was doing a number of things, getting in contact with our dispatcher, to let them know when CIB calls them, trying to get in touch with CIB, notifying my lieutenant, my supervisor of the case, and trying to make calls to Elizabeth Johnson.
And when you spoke with Elizabeth Johnson, had you already searched the home, or was that after you spoke with Elizabeth Johnson that you searched the home?
I do. When the roommate showed up, we obtained permission from him to search, do a cursory search, an exigent search for the child and for Elizabeth Johnson inside the home. We also, and I didn't, Officer Pena did that, I do believe, with another officer. And there was a storage shed in the back, locked storage shed, which I do believe he had the key to.
Okay. All right. So Officer Pena's searching the residence and the shed, and you're there also at the scene, but you're taking command and making phone calls and getting more information regarding the situation. Is that a fair statement?
Yes.
Okay. All right, so you indicate that at some point you did speak with Elizabeth Johnson on the phone.
Yes.
Okay. And when you spoke with her, what phone were you using?
My work cell phone.
Okay, and when you spoke with her, were you inside of the home, standing outside of the home?
I was outside the trailer near my car.
Okay, and were you able to successfully make contact with her the very first time you called, or?
I don't recall if it was the first or second time, but I did make contact with her.
Okay, and when you finally did get her on the phone, what happened?
I asked her if she was okay and if the baby were okay, and she said, we're fine. And I said, where are you? And she said, we're driving back. I have a hearing tomorrow, a custody hearing, so I'm driving back to Phoenix. And I said, what are you near? And she said, well, I'm on the freeway. And I said, can you give me a milepost marker? Because we need you to pull over. We need Texas law enforcement to make sure you and the baby are okay.
Now, you mentioned Texas. Did she confirm with you that she was in the state of Texas at that time?
Yes, she said she was driving back.
Okay.
In the state of Texas.
And then you asked her to give you a mile marker. And what was her response?
Yes, a mile marker and/or I said, well, she said that she didn't see any. And I said, have you passed any exits? Do you have an exit number that you're passing? And she said, I don't see any exit numbers. And I said, well, the next exit you come up on, you need to pull over. It's dire that we confirm if the baby and you are both okay.
Okay, so you explained to her why you needed this information.
Yes.
And did she give you any of that information?
No, she did not. She said that she couldn't stop, that she had to drive straight through because she had a hearing the next day, and she had to appear in that hearing.
Had she stopped or had she given you a mile marker, what would that have done?
That would have given us a location, and we could have alerted Texas DPS, or she was still in San Antonio, Bexar County, or San Antonio PD, as to her whereabouts. We'll just continue the conversation, and then I'll go into what we did after that conversation on notifying Texas.
Okay. So when you continued your conversation, what else did she tell you during that conversation?
I said, well, we really need to confirm that you and your baby are okay. And I said, I can't hear your baby. I go, can you put the phone near your baby? And I said, where is he in the car? And she said, he's in the car seat right next to me. And I said, well, can you put the phone up to your baby so I can hear that he's okay? And she goes, okay. So she puts the phone over. I could hear that she had taken it away from her person, and it was just, I could just hear road noise. And she said, did you hear that? And I said, no, I didn't hear anything. And she said, well, you're not listening close enough then, are you?
And what did you do then?
And I said, well, we really need to check on your baby to make sure. I just reiterated that. I said, did you pass any signs that give a milepost or streets that you could turn off? We really need to check. The phone went dead at that point.
And how long would you say this conversation lasted?
Approximately 5 minutes.
After the phone went dead, what action did you take next?
I immediately contacted our dispatch, and I told them to, and I requested an ENLITS, which is a law enforcement message, teletype message to be put out to all Texas law enforcement agencies on the make and model of the car, the license plate, the description of Elizabeth and her baby. It's a missing child case or custody case, and we needed to immediately locate them.
Okay. And did you take any further action that day regarding that phone call?
Yes. I requested our dispatch ping the cell phone, which in emergency cases, cell phone companies do for us, for the police, to try to locate where the cell phone is and the nearest tower. And there were several towers that the cell phone was pinging off of and making contact with. And instead of the pinging getting closer to the Phoenix area or going westbound, the ping were pinging on Brownsville, which is south and opposite the Phoenix area.
And when you use the word pinging, just so we're clear, does that mean that there's an ability to locate where that cell phone is?
Yes, when I'm not very electronically astute, but when they have to make contact with the cell phone towers to transmit to another cell phone tower to give the call, connect the call. And it was pinging off of those other cell phone towers.
So once you made the request, you were receiving information that this cell phone was being used or tracked during that time?
Yes.
But it was contrary to what Elizabeth Johnson had told you?
Yes.
That she was on her way back to Phoenix?
Yes.
Okay. Do you recall approximately what time you spoke with Elizabeth Johnson that day?
I do believe it was about 1:30.
After you got off of the phone with Elizabeth Johnson and after you made the request to locate her cell phone, did you do anything else at the scene of the home in the city of Tempe?
I briefed the command staff that arrived and also our criminal investigations staff that arrived.
All right, so when you say this command staff that arrived, what does that mean? What happened at that point?
Well, 2 lieutenants arrived because of the severity or just the case alone. And then they called out our criminal investigations command staff as well as several detectives.
And they all arrived at the trailer home. All right. And did you remain at the scene at that point or did you leave?
I remained at the scene. I don't recall what time I left, but it was several hours I was there.
And once you left the scene, did other staff remain behind?
Yes.
To maintain contact with that trailer and with the occupant of the trailer?
Yes.
All right. Where did you go at that point?
The CIB, our criminal investigations commander or lieutenant at the time, called for a meeting at the station in the Criminal Investigations Bureau to go over the information that we had.
And is that something that would occur in a case of this magnitude?
Yes.
All right. Typically, everyone gets together to give the information they've gathered throughout the last few hours?
Yes.
All right. And did you relay the information that you had received at the scene and with your phone call with Elizabeth Johnson?
Yes.
I have no further questions. Thank you.
Thank you. Cross-examination, Ms. Phillips.
Thank you, Your Honor. Good morning, Sergeant Lenzen.
Good morning, ma'am.
So on December the 27th, you did actually speak to Elizabeth,
Yes.
and that was at about 1:30, you said?
Yes.
In the afternoon.
Yes, ma'am.
And that was after that she had texted Logan that she had killed the baby.
I don't know what time that text came through on his phone because I wasn't with him. Officer Snell would know that.
Okay, but it was after you had some information that indicated there was a baby in danger.
Yes.
And so you talked to her the same day that
Yes.
she sent the text.
The same day that Mr. McQueary came in to report the
Got it.
baby,
Thank you.
within the hour.
Okay, great. Thank you for clarifying. And you're actually the only member of the Tempe Police Department to speak directly to Elizabeth after she left for Texas, aren't you?
I don't know that anybody else spoke to her. I don't have that information.
Okay, you don't know whether or not someone else did, or
I don't know if any of our detectives or officers did.
okay, to your knowledge.
To
though.
my knowledge, I don't know of anybody else.
And you did not record that conversation with Elizabeth, did you?
I did not.
And as far as you know, no one recorded that conversation.
Unless someone was eavesdropping on my phone.
As far as you know.
Yeah, I don't think my phone's plugged.
Okay, so there is no recording of that conversation to your knowledge.
Correct.
Now, you got her phone number from Logan McQueary.
From Officer Snell, who got it from Logan McQueary.
Okay, thank you for clarifying. And you did use the 210 prefix phone number, correct?
Yes, ma'am.
And that was the San Antonio phone that she had apparently picked up.
Yes.
And I assume you identified yourself as a Tempe police sergeant when you talked to her?
Yes.
And she told you that she was driving?
Yes.
And she told you that she was aware of the December 28th court hearing?
Yes, ma'am.
But she did not tell you how she knew there was a hearing, did she?
I don't believe so. She just said that she had to be at that hearing.
And so you don't know how she knew that?
No.
And she told you she was on her way back to Arizona to come to that hearing?
Yes.
And was that before or after you told her to pull over or find Texas law enforcement?
The conversation went that we got reports that the baby might be in danger, and she said, no, we're fine. So I identified myself, the reason for the call, and her response was, no, we're fine. And I didn't want to take that. And so I continued to tell her we needed her to pull over. We needed to confirm that they were both fine.
And that's when she said she was on her way back?
Yeah. Yeah.
Okay, so you told her, it sounds like numerous times, to please pull over.
Yes.
And let Texas law enforcement know that the baby was safe.
Yes.
In fact, you ordered her to do so?
I said, we need you to pull over, and we need to send a really nice Texas police officer to make sure both of you are okay.
Okay, and I assume you were fairly firm in your
Yes.
statements to her.
It was repetitive.
Okay, and you told her, in fact, you said this morning, it was dire that she confirmed that the baby was okay.
Yes.
And she refused.
Yes.
She refused repeatedly.
Yes.
And at some point you had her put the phone up to the baby so that you could hear.
Yes.
And you told her that you couldn't hear anything.
Yes, ma'am.
And you told her you couldn't hear anything. And that's when she responded to you, you're not listening close enough, are you?
Yes.
Nothing further, Your Honor.
Thank you. Redirect?
No, thank you, Your Honor.
Thank you. Before we let Sergeant Lenzen step down, does the jury have any questions for her? Doesn't look like it. May this witness be excused, Ms. Romano?
Please, thank you, Your
Ms.
Honor.
Phillips? May this witness be excused? You may step down. Thank you. And the state may call its next witness.
State called Detective Todd Bailey.
Okay, let's go ahead and get Detective Bailey.
Pull up some of that bar right there, pull it up towards you a little bit, just like that. Perfect.
Mr. Romano, you may proceed.
Thank you. Detective Bailey, would you please introduce yourself to the jury?
Sure. My name is Todd Bailey. I'm a police officer with the City of Tempe Police Department.
And Detective, what is your assignment at the City of Tempe Police Department?
I was hired in August of 1997 as a patrol officer. Spent about 4 years in our patrol division before I transferred to our Criminal Investigations Bureau, so I'm a detective. The last 5 years I've been specialized in the area of computer forensics.
And since you indicate that you've been in the area of computer forensics, do you have specialized training in that area?
Yes. Over the last 5 years, I think the last count was about 700 hours worth of computer-related training as far as recovering data, examining computers, seizing computers. It also spilled over a little bit into electronic devices, cell phones, GPS items, anything that can contain data on it. That's the training we've kind of achieved.
And in addition to the hours you've spent training to do that, have you also had experience in conducting those examinations?
Oh, yes. Over the last 5 years, I wouldn't even have a guess of where there would be over hundreds of items that we've looked at that detectives have brought in. Generally, our role is more of an assistant role. We help other detectives on all different types of cases. They'll bring in a computer. We'll help examine it and give them back the answers.
Okay. Now, Detective, I'm going to draw your attention to January 6th of 2010. Did you become involved in an investigation involving a missing baby by the name of Gabriel Johnson at that time?
Yes.
And how was it that you became involved in that investigation?
The investigation was pretty big. Most of the people in Detective Bureau kind of knew of it or were involved in one way. I believe that's when I started assisting the other detectives by looking at items that were seized or had been brought in related to that case.
Okay. And specifically, On that date, were you asked to assist in the examination of a digital camera and a Magellan Roadmate GPS device?
Yes.
Okay. And where were you when you were asked to assist in this?
At our police station, we have a forensic computer and what we call a lab. It's more of an office, but we have an office at our police department where the detectives know to find me and they can bring stuff to us.
And I'm going to focus particularly on the Magellan Roadmate GPS device. Did you assist in obtaining that device, or had it already been obtained at that point by the police department?
The Magellan, both these items had already been brought into police custody. I believe they were actually recovered in Florida and sent back to us here in Arizona. And then one of our homicide detectives arranged for me to get them.
And was there a search warrant obtained to search those items?
Yes.
Obtained by Detective Thompson specifically?
Yes.
Okay. And did you review that before you looked at either of those items?
Correct.
All right. Now, regarding the Magellan Roadmate GPS device, who was that purported to belong to?
The items all came from a backpack that was, to my understanding, belonging to Elizabeth Johnson.
Okay. And when you examined that device, what did you do?
The GPS, it can hold data on it, similar to files on a computer. There's actually a memory inside of a GPS device. In this specific brand of GPS, it doesn't keep track of where you've been. And what I mean by that is some GPSs, if I were to have the GPS in my hand and start walking out the hallway and to the right, it would track little, they call them breadcrumbs, little dots of where you've been down the hallway and to the right. This type of GPS device just stored data on where you want to go. So if I typed in, I want to go to the elevators, it would have a storage or a memory that says, hey, he typed in he wants to go to the elevators, but it wouldn't actually show that I walked down the hallway to the right. So what I did is I started looking at the evidence, first researching the Magellan to figure out what type of information it contains, and then researching the best method to get that data off of the Magellan.
Okay. And what did you do to get the data off of the Magellan?
There's a forensic program we have that you can hook up to your computer, the Magellan device to your computer actually, and it'll withdraw or extract that data to your computer, and then you can analyze the data itself. So I began that process.
And the forensic program that you use, can you explain why it's important to use that type of a program?
We use forensic programs that they're basically designed to be what we call read-only. The whole purpose is not to change any of the data that you come into contact with. And when I say read-only, for example, when you just by hooking a hard drive up to a computer, the computer, because it's designed to be user-friendly, will actually go out and scan the hard drive, and sometimes it'll, like, for example, assign it a drive letter. Well, that might make changes to the drive, and that's not our objective. Our objective is to keep the drive pristine exactly how it was when it came into our custody. So we use these forensic-type software programs and the same technique always, so that way we don't change any of the evidence that comes into our possession.
And just so I understand this correctly, this enables you to get the data off of whatever the device is exactly as it exists at that moment.
Correct, and prevent any changes to it. So you could go back and look at it today, it would be the exact same data that we had back when we first looked at it.
And once you use a forensic program, it makes a copy of whatever is on the original device, correct?
There's options to do that, not specifically in the GPS, but our forensics techniques do that. You always want to work off of a copy. So if an accident does occur, it's to that copy, not to the original.
Okay, so in regards to your procedure with the GPS device, what happened next?
We basically used the forensic software to extract the data. It pulls it off in files that are not really readable to the human. It's not a nice little language that says, I was here. It'll be coordinates and different points, which the forensic software for the GPS actually can use online tools like Google Maps and things of that nature to actually plot those points, so it makes it a little bit easier for us to understand.
Thank you. And did it generate a report?
Yes.
Okay, and is that report in a printed out form?
Yes. It saves it electronically, but I printed it out, yes.
May I approach the witness, Your Honor?
You may.
Detective, I'm showing you what's marked as Exhibit 196. Do you recognize this document?
Yes, this is the report as printed out.
Okay, and is that a 7-page document?
Correct, 7 pages.
And that is the report that printed out regarding the Magellan GPS device that you analyzed on January 6, 2010?
Yes.
All Your Honor, at this time, I would move to enter into evidence exhibit number 196.
Any objection?
Yes, Your Honor, objection is hearsay and also lack of foundation.
Well, let's start with the foundational objection. What foundation is essentially missing if he... Well, let me let you try and lay a little more foundation in terms of it being printed, and then we'll talk about the hearsay information.
Detective, this is the printout from the examination you did, correct?
Correct.
And this contains all the information that existed at that time regarding the Magellan device.
Yes, the forensic software that I used to examine the GPS device that was brought to me pulled the data off and uses the data that was extracted to create that report. I then printed that report.
Thank you.
Let's talk about the foundational objection. Why isn't that enough to lay the foundation for this document?
Your Honor, I would additionally object to its relevance as well.
Okay, that's the third one we can talk about. Let's talk about the foundation first. What's missing in the foundation?
The foundation, Your Honor, I'm concerned that there isn't enough of a connection with what he has testified to doing with the information, where he got the information from, what he did to the information to generate a map. His testimony is that the software produces information that's not in English and somehow magically produces Exhibit 196. And I'm just not clear how we get from point A to point B.
Okay, and I think there's some validity to that. We have to talk about his knowledge regarding the software used to translate the information that comes from the GPS device into that document in terms of what software is used and what his knowledge regarding that software is and what it does.
Detective, could you explain how, once you extract information from the GPS device, how it is generated into this report?
Yes. The software program itself, when I indicate that there's data stored on a GPS device, I can connect that GPS device up to my forensic computer and directly look at it. The data stored on the GPS device is in the non-English readable format that I referred to earlier. Using this software, which is a forensic-based software, it's known in the industry for GPS examinations. It is the software that once you connect to your forensic computer, it is programmed to go out to a GPS device, pull the information off, and then translate it to an English readable form. It also, once it does that, then can go out onto the internet and plot those points onto a map, which is what some of those pages are. The pages are actually maps with little points plotted on them. Those maps and that information is coming from the GPS device. It's not coming directly from me where I have to transcribe it or do something of that nature. I connect the device up to my computer, verified, that the settings are all correct, that this software program is looking at that GPS device. It's the only GPS device we've, connected at a time. We don't do more than one at a time for that reason. And the software actually pulls the information out and creates that report. It creates it like in a PDF or an electronic format, so I print it out so that way we can have a hard copy to give to detectives or to impound or do whatever we need to do with the report.
Okay, the foundation objections overruled. I think there's enough in terms of the use of common software to provide the foundation for the report we've got. So the foundation objection's overruled. Now let's talk about the hearsay objection. What's the basis for the hearsay objection?
Your Honor, the document itself is an out-of-court statement to prove whatever conclusion he's going to draw from it.
Except that how could we ever have a declarant in court? Hearsay is intended to keep or to allow us to hear directly from declarants. Here, we've got a GPS device. That's never going to be a declarant. From my perspective, this would be a situation where we could maybe shoehorn this into a hearsay objection, but realistically, I don't see it as a hearsay issue. So I'm going to overrule the hearsay objection. Let's talk about relevance now. The objection is relevance. It presumably, the device being it, has some information perhaps regarding Elizabeth Johnson's whereabouts. It seems like that would provide at least some relevance in terms of a 401.
Judge, if I may.
You may.
I'd like to reassert the foundational objection. I'll put it this way. Do you mind if I voir dire the witness?
You can.
Officer, what was the GPS device that you had that you analyzed?
The Magellan Roadmate?
The Magellan Roadmate. Okay, did you personally get the Magellan Roadmate?
Yes.
Okay. Did you personally find the Magellan Roadmate where it originated from?
It was delivered in a backpack.
It was delivered in a backpack to you
Correct.
from another person, correct?
Correct.
So you have no personal knowledge as to where it came from before you got it. Is that correct?
Correct. My examination just shows what's on the device at the time of my exam.
You have no idea about where the device came from, who had the device, and you have no personal knowledge to that.
No, my understanding from reading the search warrant.
You have no personal knowledge to where the device came from, correct?
I don't know if I can answer. I'm trying to answer that.
Did you personally get the device out of a car?
No.
Okay. You had the device delivered to you.
Yes.
Any information about the device was given to you by another person, correct?
The history of the device, I guess, would be yes.
Okay. Judge, if I may. They have not laid the proper foundation to talk about this device. Everything else is coming in through hearsay. And they have to lay the foundation about where this device came from and why it's relevant. Okay. And they've got to do that.
Mr. Ramona?
Your Honor, I would ask the court to admit the evidence pursuant to Rule 104. I believe that the foundation, as they're challenging it, can be laid with a different witness, but at this point we would ask that it be entered at this time.
I think, and I almost see it as a relevance issue as well, because we haven't yet tied it via personal knowledge into Elizabeth Johnson. He's read a report that might be considered to be hearsay, or his information might be from a hearsay source. So I'm not going to admit it now. I'll sustain the objection as to the foundation. You can lay the foundation, and if you lay the proper foundation, I don't see an issue with it. But because of his lack of knowledge regarding the source of the GPS, then I'm going to sustain the objection as to foundation, and I think a relevance objection might be well taken as well at this point.
Thank you, Your Honor. Detective Bailey, just so we're clear regarding where you obtained this device from, you obtained it from, it was impounded in Tempe Police Department's records, correct?
Objection, again, Your Honor. Same objection, Your Honor.
Overruled. He can, I think that's within his personal knowledge. Overruled.
Detective Thompson, our homicide detective, brought me the backpack.
Okay, thank you. Now I'm going to move to the date of January 10th, 2010. At that time, were you asked to assist in the examination of a Sony ICD P520 digital recorder?
Yes.
Okay. And who gave you that recorder?
I believe my sergeant brought it to my office and asked me to examine it.
Okay. And was this purported to be the recorder of Logan McQueary?
Yes.
All right. And what did you do with that recorder?
Objection, again, Your Honor. Same objection, foundation.
It doesn't. That doesn't prohibit the question as asked. Maybe if we were trying to admit some materials from that recorder, but what he did with it, I don't think there's an appropriate objection, so the objection's overruled.
Thank you. Detective, this was purported to be the recorder of Logan McQuary?
Yes.
That was the information that you were given?
Yes.
All right. May I have continuing permission to approach the witness?
You may.
I'm showing you Exhibit 166. Do you recognize that item?
Yes, this is the recorder.
And what did you do with that recorder? You can place it there.
The first thing with any items that are usually brought in, we physically examine, look for model numbers, serial numbers, the characteristics of the device, research it.
Okay. And once you did that, what did you do?
During that research, I noticed that there was a USB connector to it. Each person in the police department is actually issued a digital recorder, not that model, but they also have USB connectors in there. So we can transfer files from the recorder to a computer. I coked it up to my forensic computer in a read-only method, try to download any data that would be saved on the recorder to my forensic computer so we could play it.
Okay. And were you able to obtain those recordings?
Initially, no. The recorder actually requires a special driver and special program from Sony, the maker of the recorder. So I actually downloaded the recorder, followed the manual instructions. I was also able to find the manual, the owner's manual for that, and just followed the instructions right out of the manual on how to use their program to download the software, or download the recordings off of the device.
And at that point then, did you download those recordings?
Yes.
All right. And did you do anything else further with the recordings once you were able to download them?
Initially, they were given back to, I believe it was Detective Thompson. He came later and asked that some of them were kind of hard to understand. They were hard to hear. The software allows you to kind of mute different frequencies. And so we tried to clarify it, if that's a good word for it, just take away some of the static.
Okay. And you attempted to do that with these recordings?
Yes.
And did you make a CD or DVD with those clarified recordings on them?
Yeah, it should hold the original and then anything that's clarified.
Thank you. Now I'm going to draw your attention to the date of January 14th, 2010. Do you recall working that day?
Yes.
Okay, and do you recall what you did that day in connection with this investigation?
I was initially called or asked to stay late to assist with a search warrant at the Smith residence.
And did you in fact participate in that search?
Yes.
All right, and who else participated in the search with you?
There's two forensic examiners in Tempe, myself and a Detective Welling, and he was there. There was also several other detectives and personnel.
When you went to that where was the search warrant executed?
The Smith residence, I refer to it as North Scottsdale. We had to go all the way up to 101 and then keep going. It was a good drive from the police station. I don't know the exact address of it, but it was so far north that then you had to take a dirt road to get out to it. It was a nicer custom home.
Okay. And when you arrived at that home, were the Smiths present during
Yes.
the execution of the search warrant?
Yes.
Okay, and specifically, did you meet or see Tammi Smith that day?
I did see her. I didn't have any contact with her as far as communication. I didn't talk to her, but I did see her in the house that day.
And would you be able to recognize her again if you saw her again?
Yeah.
Do you see her in the courtroom here today?
Yes.
Would you please point to her and describe one thing that she's wearing?
She's seated at the table to your left. The female in the middle of the three, she's wearing a black outfit.
Okay, thank you. Would the record please reflect that this witness has identified the defendant?
The records shall so reflect.
Thank you. Now, what were your duties during the execution of that search warrant?
My job was to first quickly walk through the house and see if there's any electronic capable storage items, mainly computers. Look for any computers that would be in the house and assist the detectives that were there in advising them or actually doing the seizure of those items.
And were you able to find any of those items?
We did. We found a computer that was running. It was at a little desk or workstation kind of in a laundry room. There was also a laptop that was not powered on that I believe was on a kitchen table.
Once you found those items, what did you do with them?
I had been given information earlier that Ms. Smith ran a business from her home. And part of the computer process is actually seizing the computer. And if she was using that computer for her business, that would essentially shut her business down. So we had made the decision prior to going out there that if we did come into contact with a computer, that we were actually going to copy it on site. That would shut it down for an hour or two, but the idea was we could leave it running and not shut down her business. So one of the first things we did when we found the computer in the laundry room was begin that copying process. We forensically copied it again to make sure there's no data changes. But we did that so we could leave a computer there running for her.
Okay, and the computer that you found in the laundry room, what kind of computer was that?
It was like a generic desktop computer. It had, down below, and then the keyboard and monitor.
And I'm showing you what's marked as Exhibit 53. Do you recognize that item?
Yes.
And what is it?
This is the actual hard drive that we removed from that computer. So we took the original one with us and actually left one that the city of Tempe owns with the data back at her house. So this is the original hard drive that was in that computer.
Okay, so just so I understand this correctly, the hard drive that exists in Exhibit 53 is the actual hard drive from the Smith's computer?
Yes,
And you left a different hard drive in her computer at home?
correct.
And what, is that the forensic copy that you left with her?
Correct. We have a device that will copy or clone is a common term for it, clone the drive. So we shut down her computer correctly, remove that hard drive, hook it up to our device so it takes the data from that hard drive. Our device duplicators, it's designed just to copy drives as fast as possible onto another drive, which we brought with us. We then put that drive back into the computer and turned it on, make sure it was running, and we took the original drive with us.
Thank you. The state would move to enter into evidence Exhibit 53.
Any objection?
Your Honor, I would object as to relevance. I'm not sure why it's relevant, why the hard drive itself is relevant.
I think under the circumstances, there's enough relevance without any argument that there's a 403 issue, so I'm overruling the objection.
Thank you.
Exhibit number 53 is admitted.
Now, Detective, I'm showing you what's marked as Exhibit 64. Do you recognize that item?
Yes.
And what is that item?
That's the laptop that was found in the kitchen.
Now, Detective, did you conduct forensic examination on either of these items?
What I'll call a forensic examination, no.
Did you conduct any type of examination on those items?
Yes.
And which item did you conduct an examination on?
Technically both. The idea at that point was we had a missing child, so we connected to our forensic computer, both the hard drive by itself and then later the hard drive that was inside the laptop. And forensically, I can look at the data on the drives without changing them and do searches for different items, looking to see if there's any information on there that might tell us where the missing child was.
And is that what would be called a preview?
I would call it a preview.
Okay, and essentially that looks at the information on the computer in a cursory manner,
Yes.
looking for immediate information at that time.
Yes.
Okay, and were you able to find anything of evidentiary value at that time?
I didn't note anything that I believed was evidentiary value for the location of the child. I mean, that was what my goal was.
Okay. Now, at some point later, did your attention get drawn back to Miss Smith's computer hard drive?
Yes.
And what happened? Tell us about that.
A few days later, Detective Ramirez actually contacted me saying that Ms. Smith had left a voicemail or had called her and asked for a file that was on that computer. The computer, as I indicated before, was copied, so it should have been at her house and available to her, but apparently she was having some issues retrieving it. So she relayed information to Detective Ramirez asking about this file that was on her computer before we came. Detective Ramirez then asked me, can you see if this file is there?
Overruled is not, I don't think, offered for the truth of the matter asserted. Overruled, you can answer the question.
So Detective Ramirez provided information about the file that Tammi Smith was looking for, and I looked at the drive again to see if I could find the file and where it was.
Okay. And did you, in fact, find the file that was being searched for?
Yes.
And when you found that file, did you look at the actual document itself?
Yeah, it was a Word document. It was a file.
Okay, and what was the name of the file? If you
I believe it was visit.doc, visit.doc.
And were you able to determine when that file was created?
Yes.
And when was that file created?
Microsoft Word keeps properties of the files. And so you can actually, when you when you create a document for the first time, it'll actually keep the information in the program, in the file itself. That information indicated that the file was created on December 18th of 2009.
Okay, and does it indicate what time that the file was created on December 18th, 2009?
Yes, the time of 4:07 p.m.
Did it also indicate any other information regarding that document?
It does track other items, revision times and modified times and printed times. Unfortunately, by the fact that I'm looking at it, it changes the modified time, so that's updated. The printed time also indicated the same date, but at 4:33 p.m.
I'm showing you what's marked as Exhibit 60. Detective, would you please pull out the first page of that? And does that look familiar to you?
Yes, this is a printed version of the Microsoft Word document that I was asked to find.
Okay, and that is the one that you found in the hard drive?
Correct.
Is this the specific printout you found, or does this represent what you saw on the hard drive?
Detective Ramirez had asked and provided information about this file saying, can I find it? I found the Word document and actually emailed it back to Detective Ramirez. I didn't actually print it out.
Okay, thank you. May I have one moment, Your Honor?
You may.
The state will move to enter into evidence exhibit number 60 at this time.
Any objection?
Objection, Your Honor. Again, foundation. Detective Bailey has indicated he did not print it out. He indicated that there may have been modified times on the document. We don't know. How do we know what it's purported to be, or the implication is that Ms. Smith created it. So how do we know that it wasn't tampered with by somebody else?
Well, that's a different analysis from the foundational analysis. He testified that that's the document he viewed and that he emailed. I think that lays a sufficient foundation, and he testified as to where he got it from and that he emailed it to Detective Ramirez. I don't think there's a foundational issue with that based on his own knowledge, and so the objection is overruled.
Your Honor, in addition, Detective Duplessis did lay additional foundation regarding this document last week, that it was found in the home and impounded into evidence at that time.
The objection is overruled. Exhibit 60 is admitted.
Thank you. I have no further questions.
Thank you. Cross-examination, Ms. Phillips.
Your Honor, do you think, given the hour, we could wait until after the lunch hour, please?
Okay, I'll take that as a request so we don't jump into the middle of a witness and stop in the middle, and that makes sense. So, ladies and gentlemen, we're going to take our lunch break, and then we'll come back with the cross-examination of Detective Bailey. So, if you'd please be back at 1:25, and we should start right on time at 1:30. Until then, remember the admonition, and we'll see you at 1:30.
All rise for the jury.
Okay, please be seated, everyone. We are outside the presence of the jury. I want to talk about Exhibit 196, just to go back to that so I can be clear as to what my ruling was and why I didn't admit it. I think my concern was not the process by which he obtained the document from the GPS. My concern is that it was being represented to have come from Elizabeth Johnson's backpack, but he didn't have the personal knowledge. And to me, it's foundational and could be relevance if it came from somewhere else. So you need to tie that. I don't see Rule 104 as giving you a basis to allow that in under the circumstances. I know the state cited to Rule 104. I think there needs to be more information as to where it came from. Once you have that, I think you're okay.
And, Your Honor, if I may address it, I know it was Ms. Ramono's witness. The issue we have in this case, Your Honor, there are a great number of pieces of evidence that will be admitted, and each of the detectives took a part in doing this piece or that piece. The only way to admit the foundation the defense is requiring us to admit before we admit items is to recall each detective repeatedly. For instance, we would have to call Detective Bailey and ask him about this part of his testimony, the recorder and everything. And then we'd have to bring in Detective Thompson, who obtained the items and impounded them And he'd have to testify to that, but Detective Thompson would be testifying about other pieces of evidence that other detectives did information with, like, for instance, Detective Ramirez did a lot of things with pieces of evidence that other detectives obtained. So we believe that Rule 104 allows us to present evidence based on the fact that we expect to be able to lay the foundation, because that's our concern. If we're not allowed to admit evidence until a time in which each detective who's had their hands on the property is able to testify, then I don't see how we're going to be able to do this without calling the detectives repeatedly to talk about each piece of evidence. My concern as well, Your Honor, is we're not required to show every piece in the chain, every chain in regard to evidence. It goes to weight, not admissibility, and so it's up to the jury to determine whether or not they find that we've laid enough foundation to show that the item was actually obtained from Elizabeth Johnson. And my other concern is regarding the foundation, and this may be something we have to hear from the defense. They're objecting the foundation because Detective Bailey is not the one who got it from Elizabeth Johnson in Miami. Neither are any of the detectives we have slated to testify. Essentially, a Miami detective obtained it, sent it to the Tempe Police Department along with the receipt showing the property, and we expect Detective Thompson to testify about that. However, we don't expect the Miami police officer to testify. If they're objecting on grounds for foundation because we don't have that Miami police officer, we need to know now so we can get him a ticket and get him out here.
Okay, well, you covered several items. It sounds to me like they're about to object based on what Mr. Lee said, that you don't have the chain. I disagree with you that the jury decides whether there's proper foundation. At a certain level, they decide whether the document is or has the meaning that one side argues that it has. But there's a first level foundational call made by me, whether it gets to the jury or not, and that's what we're talking about. I understand the concern about having a lot of moving parts and a lot of witnesses, and I understand the purpose of 104. What I think should happen is, to the extent I get the chain necessary, at least that I believe is necessary, then I could admit it. And we may have a special issue relating to the Florida seizure that we'll have to work through. But, for example, with respect to the recorder, if there was going to be an objection there, I would overrule it because Mr. McQueary testified he gave it to the sergeant and he testified he got it from the sergeant. That's good enough, realistically, in terms of the chain. So I think you can close the chain as to most everything. It may be simply a timing issue of when it comes in, but I do think that if there's not evidence of clearly a chain of custody, that they're entitled to make the state show the chain of custody and where it came from. If we have to talk about the Florida issue, we can. I take it, and I guess I'll turn to Mr. Lee. Are you going to object to any information obtained from the GPS device or anything else from Ms. Johnson in Florida on a foundational basis?
Absolutely, Judge. And beyond that, she has a right to confront and cross-examine her accusers. And that goes to flat out where they got it from and who got it. And there's a constitutional issue there as well. I mean, this is huge. They've had this case a long time. The rules are out there. They know what the rules are. Follow them. And that's all that we're asking. Get their witnesses in here. If they need to fly somebody out from Miami, great. I'm sure that, they want to go from, it's a dry heat out here, so I'm sure they'd be pleasantly surprised at our warm weather compared to theirs. But they've got to do it. They've got to do it.
I'll hear you on it, but my inclination is you want to get the items seized in Florida, there's a foundational requirement to have the person that seized it. Now, we could have an issue regarding, is there a receipt? Is that an official document? Can they rely on it? And that's a possibility. If you've got a receipt and you can convince me that that document comes in, and you may be able to, and that they reasonably relied on it for what it is, I'd hear you on it. But I do think that there is the potential for an issue relating to the items taken in Florida.
And, Your Honor, I may point out as well that the defendant is the one who told the police there was a GPS device in the co-defendant's possession.
Okay. Well, you bring that out, it might help you. In that regard, we couldn't bring it out through that witness. Mr. Lee, I'm not deciding anything now. I'm just giving you a forecast of the issues that we could have so we can address it in an appropriate manner going forward. Mr. Lee?
If I may, this is not just a chain of custody issue. Yeah, that's an issue here. but it goes to flat out, is it relevant? And where did they get it from? And our ability to cross-examine and confront her accuser, which is the Miami detective or police officer, law enforcement personnel, whoever it might have been. They've got to be here. And as soon as they say, oh, we're letting that in, as soon as you say, Judge, that's going in, well, it goes back to the jury. They can do with it what they want. And we'll have had no chance to show that it's not relevant. We'll have no chance to have cross-examined the person who took it, to find out how they got it, where they got it, why they got it. And it's more than just a receipt. It just, you cannot just set that aside and say that it's just a chain of custody issue. Yeah, that's part of it. But the rest of it goes to our ability to cross-examine and to make sure that she has a fair trial here.
Well, I don't see it as much as a relevance issue. I can determine the relevance, I think, of the item itself. To me, it's a foundation issue, and I have not let it in for the reasons that I've set forth. The state obviously is free to make another run at it, and we can figure it out as we go forward. So I think these issues should be taken up outside the jury. I don't want you to make another run at it in front of the jury where we have to either get into a sidebar discussion or try and work through it in front of the jury. So this is going to be an outside the jury issue, I think, that we're going to have to determine. All right, anything else we need to talk about right now? From the state's perspective?
No, Your Honor.
From the defendant's perspective? No, Your Honor. All right, I'll see everybody at 1:30. Okay, we're back in Ms. Smith's case. We're outside the presence of the jury. I understand that someone wanted to speak to me, so what do we need to talk about?
Yes, Your Honor. We'd like to address the issue of the foundation regarding Exhibit 196 at this time.
Okay, I'm happy to talk to you about it. I'm not as excited about doing it now while the jury's waiting. I'd rather do it, if we could, at the end of the day, but if you are really compelled where you need to get it in or feel like you need to get it in for this witness, then I guess I'll hear you on it.
Well, Your Honor, we do have information regarding the receipt of the evidence, and it pertains to this witness because he was present when it was received at the Tempe Police Department.
Okay. Why don't you explain?
Would you like an offer of proof as to the...
First, why don't you tell me what's coming, and then we can talk about whether I need an offer of proof.
Okay, well, we've determined over the lunch break, and we actually have the box here that was sent from the Miami Police Department to the Tempe Police Department, that it was received by Detective Thompson and Detective Bailey was present while it was initially opened, and that within that box contains the GPS device that we are seeking to admit the evidence from at this time. There is a receipt documenting what was taken from Elizabeth Johnson, and it indicates that she was the owner of these items on this receipt, and it is clearly in this packaged and sealed box.
Anticipating what I think Mr. Lee would tell me, he'd say, I need the person who wrote on the receipt to verify it is what we said it was, is what I would expect. Is that correct, Mr. Lee?
Judge? It is, and I'd put it out a little further than that. Judge, we have to have somebody who actually went and physically collected this item to put it in context, and the Constitution requires it, and I'd point the court to two cases, Crawford, of course, but more importantly, Bull Cumming. That particular case, to just kind of narrow it down, you had somebody accused of an aggravated DUI. They had a lab tech that actually ran the sample through the gas chromatograph who was fired or was no longer working at the lab, and then the state of New Mexico tried to enter that particular document in under another lab tech that didn't work there. Court says no way. The document can't speak for itself. The document can't testify. That doesn't come in. It offends the Sixth Amendment right to cross-examination, to counsel, and on and on. And this is that same case. Whether we've got a receipt or not, in the civil world, may well be fine, but in the criminal world, we have the Sixth Amendment, and it keeps us from doing that. We have to, and she has a right to be able to cross-examine the person that went and found that so that we can put it in context, so that we can know that it came, or at least have the best that we can, evidence that it came from where they say it came from. And just a document or somebody signed it and sent it's not good enough. They've got to actually have testimony to come in and say, I went and got this GPS and Elizabeth was holding it right in her hand when I got it, or they found it in a backpack, or wherever they found it. But they've got to have somebody to come and say that and tie that to her. And if they can't do that, it doesn't come in, because we can't cross-examine on it. They can't establish the relevance of it. It just does not come in.
Mr. Ramuno, Bull Cummings says, and I think it basically says what Mr. Lee says, it says that if information from the crime lab isn't good without the chain of custody being more appropriately established. I'm not sure how we get this in just with the receipt. I know I talked about the receipt previously, and that might have led you to think, well, if we can show that there's a receipt and somebody got it, that might be enough. But I'm persuaded, I think, by the defense argument that you need more than just the receipt under these circumstances.
Well, Your Honor, I haven't been able to analyze that case in the context of what we have before the court today. I'm more than happy to do that.
I guess, and I don't mean to cut you off, I guess my response is you're not getting me there in terms of admission of 196, at least not yet. You're always free to make a run at it, and we can talk about it. But right now, I agree, at least it seems to me, that we're probably going to be in a position where I need more. I need something along the lines of what Mr. Lee believes we need, which is we need somebody that's there for confrontation purposes. I do agree with that. So you're free to argue otherwise if you have a case that you think is more on point than the Bull Cummings case. So for now, I'm not going to admit that exhibit. Anything else we need to talk about?
Yeah, sure. There is one thing. Obviously, there's two counsel on each side, and ordinarily, when you have two counsel, only one counsel addresses the court when dealing with a particular witness. For instance, when Ms. Ramuno has a witness, I shouldn't be objecting, I shouldn't be addressing the court, and we'd ask the court order that the defense comply with what's normal proceedings when you have multiple counsel.
I'm aware of that. I'm more concerned with double teaming a witness or double teaming counsel. If you're arguing and then I'm hearing it from both Ms. Phillips and Mr. Lee, then I have an issue. But even though it may be someone else's witness, I'm okay with the other attorney arguing if they're more comfortable. That doesn't trouble me. I just don't want the double teaming or two people making the same argument. That's my concern. So I'm not troubled by Mr. Lee making the argument and Ms. Phillips examining the witness.
Yeah, I'm not so concerned with the argument either. It's more the objections. Two counsel making objections during the same witness.
And that's, I think, well taken. Let's make sure it's one person making an objection per witness, so it's not both. I think that's an appropriate request, so let's keep it to one attorney per witness that's going to be objecting and explaining the basis for the objections. Anything else?
Yeah, we just need a quick moment with the exhibits before we resume.
Okay, I'll stay out here. Let's go ahead. And as soon as you're ready, we'll get going.
And if I may, I know I indicated that I was finished with the witness on direct examination. However, I would like to publish Exhibit 60 to the jury prior to his cross-examination. If I may be allowed to do so.
You can. Do you want him up? I'm okay. There haven't been questions asked. If you want to put him back up to answer questions about it, you can. Would you want to do that? Okay. So we'll get Detective Bailey back up and we'll start cross-examination afterwards. Before the jury gets here, let me get either Ms. Phillips or Mr. Lee. We have what is proposed to be marked as a new exhibit here that's in a box. And it's got multiple items, but you want to mark it as one exhibit. Is that?
We only went in to admit the report, so I don't believe it's necessary to separate these items.
Okay,
but the defense may have a different position. If the clerk's willing to take custody of it, I just didn't want the detective to have to take it back since he brought it today.
Okay, and I'm fine with that. Why don't we mark the box as an exhibit? If it's exhibit 200, then it can be 200. Is it A, B? I always get mixed up.
001.
001, 002 for anything that's inside of it.
Well, we don't even know how many things are inside of it.
Well, I'm assuming you're going to get a chance to look in there, and we're not going to do anything with it until you see what's in the box.
It was not our intention to do anything with it at all today, Your Honor. It's the GPS device itself, because of the foundation issue. We brought it.
Okay.
We don't want, now that it's here, we don't want the detective to have to take it away and bring it back.
But I do. They are entitled to take a look at the box and what's in there. So what you're telling me is the GPS device came in the box, right?
Right.
Okay, so you're, of course, entitled to look in the box and see what's in there. And if we're going to talk about it now, we need to give them time to do that.
I don't think it was our intention to deal with it now.
Okay. We're not dealing with it now? Great. So we
This
can...
is from the court's ruling, we need to bring in more witnesses to lay the foundation.
So we have
just
time
didn't
at
want the detective to have to pick it up.
We have time at the break and afterwards to figure out what we're going to do. So we won't do anything with the box until you get a chance. Okay, so Ms. Ramuno, let me know when you're ready. You're ready? Yes. Okay, so where is Detective Bailey at? Oh. You're hiding right next to me. The best place you could hide. Okay, so we're ready to go, and then, so you're going to start with some more questions? Okay, all right, so let's go ahead and get the jury. We're going to go ahead and get the jury now. All right, please be seated, everyone. Welcome back. Sometimes I'm already out here. This was one of those times. Hope you had a good lunch. And we left off, we were going to start cross-examination of Detective Bailey. I think the state may have another few questions for Detective Bailey before we start, so we're not going to get into cross-examination right away. We're going to have a few more questions from the state. So, Ms. Ramuno, you may proceed.
Thank you, Your Honor. Detective Bailey, you testified earlier about a document that you located on Ms. Smith's hard drive.
Yes.
And you identified it as being the first page in exhibit number 60. Okay, and I'm just going to show it to you at this time. Okay, if you'll take a look up at the screen here, is this the document that you found in her hard drive?
Correct.
Okay. And would you mind reading it for the record?
Sure. The first line says date, Saturday, December 20th, 2009. Logan Scott McQueary has informed me that Judge Michael McVeigh ordered a visitation for Gabriel Scott Johnson on Saturday, December 20th, 2009, from 8 a.m. until Monday, December 22nd, 2009 at 8 a.m. It was not my understanding that this was an official order, but Logan Scott McQueary told me that he would file something against me in court if I did not have the baby ready for him to take on Saturday at 8 a.m. I want to do the right thing legally. Therefore, I am surrendering the child for a visit. Since I do not receive any child support, I am only going to furnish one full bottle of formula, one diaper, a couple of diaper wipes, one blanket, and one sleeper. I just can't afford to replace items that are not returned. In return, I expect Logan Scott McQueary to drop Gabriel Scott Johnson off to me on time on Monday, December 22nd at 8 a.m. Address, phone number where Gabriel Scott Johnson will be sleeping during this visit. By signing this, we both agree to stick to this agreement for this visit with Gabriel Scott Johnson in order for all of us, especially Gabriel, to feel secure. Elizabeth Joanne Johnson, Logan Scott McQueary.
And for the record, would you please indicate how Joanne is spelled on this document?
Joanne at the very bottom there is Joann.
Thank you. I have no further questions at this time, Your Honor.
Thank you. Cross-examination, Ms. Phillips.
Thank you, Your Honor. We have no questions of this witness.
Thank you. Does the jury have any questions for Detective Bailey before he steps down? Doesn't look like it. May this witness be excused, Ms. Ramuno? Ms. Phillips? You may sit down. Thank you. And the state may call its next witness.
Your Honor, the state calls Detective Naomi Galbraith.
Okay, if we go ahead and get the detective, please. Ms. Andrews, you may proceed.
Thank you, Your Honor. Good afternoon, Detective. Would you please introduce yourself?
My name is Detective Naomi Galbraith, and I work for the Tempe Police Department.
What is it that you do for the Tempe Police Department?
I am a detective.
And what type of work do you do as a detective?
Predominantly, I focus on financial crimes, different sorts of financial crimes.
How long have you worked for the Tempe Police Department?
Since 2001.
Back
in January of 2010, were you also working as a financial crimes detective?
I was.
At that time, did you become involved in an investigation regarding a missing child by the name of Gabriel Johnson?
I was.
Prior to January 4th, 2010, were you involved in that investigation in any way?
I was not.
On January 4th, 2010, were you asked to participate in the investigation?
I was.
And what were you asked to do?
Preliminary, my job preliminary was to look at the financials for Elizabeth Johnson, and so that we could track and see where perhaps she might have gone.
And when you say you were looking at the financials, how is it that you go about looking at someone's financials?
Start off by pulling a financial profile, maybe a credit history, to see where it is that they bank, so that we can start looking to see where the expenditures are made, maybe what other accounts they have, again, for the same purpose, to look for where the money is coming in from, how much money is coming in, and where it's getting expended, so we can follow movements of people.
In looking at someone's financials, are you looking for possibly their bank records?
That is correct.
Do you sometimes look into their mortgage or property ownership or rent?
Yes, there's many reasons for looking at their accounts for things like mortgages, because you can find out perhaps what assets they have, and that will lead you to being able to figure out what that asset is, whether it's a vehicle or perhaps it might show property where you might have another property where you might live, perhaps family or things of that nature.
And when you're looking at someone's financials, do you have to have a court order or a search warrant in order to look at that information?
To get into the details of someone's finances, like from a banking financial institution, you do need a court order, correct?
And in this case, you indicated you looked into the financials of Elizabeth Johnson?
That's correct.
Did you also look into the financials of Tammi Smith and Jack Smith?
I did.
And did you have court orders to look into the financials of all of those people?
I did.
In regard to Tammi Smith and Jack Smith, did you find anything in the financial records that would lead you to find Gabriel Johnson?
I did not.
In looking at Elizabeth Johnson's records, did you look at her debit card?
I did.
Did you receive information regarding her debit card?
I did.
And was that from J.P. Morgan Chase Bank?
For Elizabeth Johnson?
Yes.
Compass Bank? BBVA?
If your report says January 11, 2010, I received the subpoenaed mail documentation of Elizabeth Johnson's J.P. Morgan Chase Bank debit information, is that correct?
That would be correct.
And when you received that information, did it indicate what her bank balance was on December 12, 2009?
It did.
And what was that bank balance?
It was an estimated $485.
$485.16 sound correct?
That does sound correct.
And was there any activity showing on that account between December 12th, 2009 and December 18th, 2009?
Correct, there was. On the 18th.
Okay, but between the 18th and the 12th, was there any activity?
Not to my recollection. I would have to look at the bank statements.
On December, you indicated that on December 18th, 2009, you saw activity on that account.
Correct.
And did you see activity that occurred at 10:05 in the morning of December 18th, 2009?
I did.
What was that activity?
That was an ATM withdrawal for $480.
And was that at a location in Tempe, Arizona?
It was.
Do you remember the address?
I don't remember the exact address. I do recall the cross streets.
What were the cross streets?
Southern and 48th Street, I believe.
And did you note other activity on that same account later on December 18, 2009?
I did.
And when was the next activity you noticed?
The exact time I do not recall.
You indicated in your report it was 1755 hours. Does that sound right?
Correct. I remember it was in the evening.
And what was the activity you noted at that time?
It was for, it zeroed out the balance, so it was for $5 and change.
And was there an address indicated on where that was?
There was on the bank statement.
And is that an address of 8823 East Chaparral in Scottsdale, Arizona?
That's correct.
In looking at Elizabeth Johnson's financial records, did you also look into her Department of Economic Security records?
I did.
And were you able to obtain information from those records that indicated what income she was receiving?
At this point, I'm going to object. The state's been leading the witness. At this point, there needs to be more question and answer, please.
We are leading at times, although that question I don't think is a problem. There has been some leading, but she can answer that question.
I did conduct a DES check to see what kind of benefits maybe Elizabeth Johnson was getting. She was receiving $222. I believe it was bi-monthly.
And was there any other income reported in the financial documents you looked at for Elizabeth Johnson? On January 12th, 2010, did you assist in executing a search warrant on Elizabeth Johnson's home?
I did.
And what role did you play in that search warrant?
Searcher. I assisted with looking for items that were on the affidavit, and that included financial information for Elizabeth Johnson.
And did you provide those items to somebody who might have been considered a scribe?
Correct.
And you indicated previously, well, let me ask you this. Have you ever returned a search warrant in this case?
I have.
What does that mean?
That means I take a listing of all the items that we removed from the search warrant, and I provide it back to the judge so that they can know the items that were taken.
And did you return the search warrant from the Elizabeth Johnson's house on January 12th, 2010?
I did.
On January 14th, 2010, did you assist in a search warrant of Tammi Smith's home?
I did.
And what did you do with that search?
I was also a searcher for that search warrant.
And as a searcher during that search warrant, did you obtain any items?
I did.
And did you provide those to anybody who would be considered a scribe?
That is correct.
And who was the scribe at that search warrant?
Detective Gary Duplessis.
On January 11th, 2010, did you assist in this investigation regarding the name Craig Cherry?
I did.
What did you do?
I was tasked with looking in to see if Craig Cherry had fathered any children at all. So I began my investigation with vital records for the state of Arizona to see if there were any records from 2005 to that date of him fathering any child, and I found that there were not.
During your investigation, were you assigned to follow up on some leads or tips?
I was.
What exactly would you consider generally a lead or a tip in this case?
Leads and tips came in from all across the country, from people who believed they might have information that could be relevant in relation to Gabriel being, sighting of Gabriel and where his whereabouts were.
Do you recall how many different leads or tips that you followed up on in this case?
I believe I followed up on 16.
And who was responsible for assigning the follow-up on those tips?
There were two sergeants, Sergeant Lookow and Sergeant Brodnock were predominantly the ones who provided me with requests to do further follow-up on tips.
And as one of those tips, did you talk to a person by the name of Jacob Roberts?
I did.
And was that on January 9th, 2010?
That is correct.
In this case, did you provide some documentation to Alan Kreitle of DPS?
I did.
Who's Alan Kreitle?
Alan Kreitle is a detective with DPS, Department of Public Safety here in Arizona, and he is a handwriting expert.
And the documentation that you provided him, where did you physically get it?
I received the documentation from Detective Ramirez.
And how did you get it to Alan Kreitle of DPS?
Depending on the items, there were a few items that I had made photocopies of, and I hand-delivered them to him. And there were a couple of items that I received out of evidence. I checked them out, and I physically drove them over and provided them to DPS.
Let's talk about the items specifically.
Okay.
Your Honor, permission to approach the witness?
You may.
Detective, I've been...
Can we see what the witness is being shown, please? Thank you.
All right, Detective. I'm showing you, first of all, what's been marked as exhibit number 41. Could you please take a look at that document, see if you recognize that?
I do.
And is that an item you provided to Alan Kreitle of the DPS Crime Lab?
It is.
Is that an item you received from Impound?
Correct.
Were you also present at the search warrant when that was obtained?
I was.
And was that obtained from the search warrant at Tammi Smith's house?
It was.
And is that an item that was impounded by Detective Duplessis during that search warrant?
That is correct.
Your Honor, at this time I move for the admission of exhibit number 41.
Any objection?
I would object as to relevance, Your Honor.
I think the relevance is related to the handwriting, is that correct?
Yes, Your Honor.
Overruled. Exhibit 41 is admitted.
Detective, I'm going to have you take a look at exhibit number 61. Those items?
I do.
And what do you recognize those as?
This specific item is a child custody, a copy of a child custody agreement.
How do you know it's a copy?
Because I made the copy
So that's a copy you actually made of the agreement?
of the original
And where did you get the original to make that copy?
from Detective Gary Duplessis.
And the other items, other documents in that item?
This right here is an original of a handwriting sample obtained I received it from Detective Ramirez and was told that it was provided to her by Tammi Smith.
And when you received that item from Detective Ramirez, did you physically obtain it from her while she was in the presence of Tammi Smith?
I did not.
Detective Ramirez provided that item to you?
Correct.
If Detective Ramirez indicates that she provided it to you during an interview with Tammi Smith, would you disagree with that?
Objection, Your Honor. Hearsay.
It's also leading sustained.
Your Honor, it's impeachment.
It is, but it is getting into a hearsay statement. I think we've got to lay the foundation with Detective Ramirez.
Well, let me ask you this, Detective. You remember when and where you obtained that from Detective Ramirez?
Correct. I was at the headquarter building of Tempe Police Station.
And do you recall where Detective Ramirez was when you obtained that?
I believe that I was at her desk.
And what's the other item in the exhibit?
Beneath it are copies of checks from the account of Tammi Smith.
And where did you obtain them?
From the court order, from the bank statements. From this specific bank is Bank of America.
And you indicate from the court order, is that the court order you obtained?
Correct, that I served to Bank of America requesting financial documents.
And did they then send those documents to you?
They did send them to me.
Okay. Detective, you go ahead and package that back up together. Actually, I'm going to go stand up. Detective, on exhibit number 41, you indicated that was a copy that you made of that court document. That was a copy of the court document that you made, correct?
Correct.
And you provided that to Alan Kreitle, I believe you testified to?
Correct.
At some point in time, did you provide him with additional documentation?
I did. A few days later, he requested that.
Objection, hearsay.
Sustained. Just answer the question was, did you provide him with further information?
Yes.
And what was the later documentation you provided to him?
The original document for the court order, or the custody order.
And where did you obtain that original document?
From Impound.
And would you take a look at exhibit number 63, which has already been admitted into evidence that's in front of you?
Yes.
And tell us if you recognize that.
Yes.
And what do you recognize that as?
I recognize this as the original document handwriting that I provided to Detective Kreitle.
I have no further questions.
Thank you. Cross-examination, Ms. Phillips.
Good afternoon, Detective Galbraith.
Good afternoon.
You did not actually become involved in this case until January 4th of 2010, correct?
Correct.
And you stated that you were brought in to try and help find Elizabeth through her financial records, correct?
Correct.
And at the time, you worked in the financial or document crimes for City of Tempe, correct?
That is correct.
Okay. And so you looked at Elizabeth's financial records, correct?
Yes.
And you looked at the Smiths' financial records?
Yes.
And to learn about this case, initially you attended a briefing at the police department, correct?
Yes.
And then after the briefing, you drafted the subpoena for those financial records.
Correct.
You also requested a subpoena. Strike that. When you request a subpoena, you have to file an affidavit with that subpoena.
Yes.
Explaining why you need the subpoena.
Yes.
Okay. And a subpoena is just a court order.
Correct.
Okay, so you have to fill in some information for the court so the court knows why you're asking for this order.
Yes.
So basically, you're explaining why the Tempe Police Department needs these records.
Yes.
Now, at that point, you had not done any investigation of your own, correct?
That is also correct.
Everything you knew was what you learned from the briefing.
Yes.
Okay, and that information was obtained from whoever gave the briefing, correct?
Correct, and the people in it.
Okay. Now, you received a number of financial documents, didn't you?
I did.
And you reviewed them very carefully?
Yes.
Okay. And you talked a little bit on direct about that Elizabeth was getting money from the Department of Economic Security, correct?
That's correct.
And basically that's public assistance in Arizona, right?
It is.
And she was actually getting $222 a week from DES, wasn't she?
I could not remember if it was biweekly or weekly. I thought it was biweekly, but if that could be accurate, I would have to review the DES again.
Okay, and you wrote a supplement in this case?
I did.
And you wrote a supplement dated January 25th, 2010?
Yes.
And if I told you that in your supplement you wrote that she was receiving $222 a week in DES welfare assistance,
That's accurate.
would you have any reason to dispute that?
No reason to dispute that.
Okay. So basically what happens, as I understand it, is that DES supplies a person with a bank card, correct?
Correct.
Like a debit card.
Correct.
And they put money on that account each week.
Correct.
Electronically.
Yes.
So they don't send a person a new card every week. They just load that existing card once a week.
That's accurate.
Okay, and that's what Elizabeth had.
Yes.
And you were able to ascertain that she was able to use this card while she was out of state, right?
The last use was in Arizona.
But she was able to withdraw funds as they became available.
Correct.
Okay. And that was the date you talked about when she withdrew about $485?
That's correct.
Okay. Now, you thoroughly examined the Smith bank records.
Correct.
You examined their Bank of America account.
I did.
You examined their Capital One account.
Correct.
You examined their Wells Fargo home mortgage account.
Yes.
Their Bank of America credit card.
Yes.
And the Bank of America credit card, the Bank of America account for Tammy's business.
Yes.
You examined all of those.
I did.
And specifically, you were looking to see if perhaps they had given money to Elizabeth, right?
I was.
And you were able to determine that they had not given any money to Elizabeth, according to these records.
According to the records, there was nothing glaring that made me believe that.
Okay, nothing glaring, nothing that you saw that would indicate that they were giving Elizabeth any money.
Correct.
Nothing further, Your Honor.
Thank you. Redirect?
No, Your Honor.
Okay, before we let Detective Galbraith step down, does the jury have any questions for her? Doesn't look like it. May this witness be excused?
Yes, Your Honor.
May this witness be excused? You may step down. Thank you, Detective. And the state may call its next witness.
Thank you, Your Honor. The state calls Alan Kreitle.
Okay. Go ahead and get Mr. Kreitle. And Ms. Andrews, you may proceed.
Thank you, Your Honor. Good afternoon. Would you please introduce yourself?
My name is Alan Kreitle. I'm a forensic document examiner with the Arizona Department of Public Safety Crime Lab here in Phoenix.
What exactly is a forensic document examiner?
Well, the bulk of our casework deals with looking at handwriting cases to determine who did or did not execute a body of writing or a signature. We also look at suspect documents such as counterfeit currency, counterfeit ID cards, almost anything you can think of that deals with the authenticity or the authorship of a document.
And how long have you worked for DPS in that capacity?
I've been with DPS for 19 years, and in the last 13 years in the capacity as a document examiner.
What were you doing with DPS prior to becoming a document examiner?
I first hired on with DPS. I was a member of our controlled substance unit, analyzing drugs and responding to crime scenes.
And DPS, Department of Public Safety?
That's correct.
When you examine documents working for the Department of Public Safety, who do you examine documents for?
Our laboratory accepts cases from any law enforcement agency within Arizona, and also federal agencies such as the FBI and DEA.
And how many document examiners currently work for the Department of Public Safety?
We have 2 full-time examiners and then also a supervisor who's also a trained examiner, so 3 total.
What type of training have you received to become a document examiner?
I have a Bachelor of Science in Forensic Science from Michigan State University. However, the bulk of my training to become a document examiner is a 2-year on-the-job apprenticeship with the senior examiner at the laboratory. It also includes 2 weeks of training with the Secret Service and a week with the FBI.
Explain a little more what was involved in your apprenticeship.
Well, the bulk of it's working side by side with a qualified examiner, looking at as many types of handwriting as you can expose yourself to, reading appropriate articles and books, exposing yourself to the field in general. But the most of the training is working side by side, looking at how handwriting cases are performed and just getting a feel for the field in general, and writing reports and training and testifying as well.
When you are examining a document, what is it that you're looking for when you're trying to analyze for handwriting?
Well, the basic, in doing a handwriting comparison, obviously we're looking to determine if a certain individual did or did not execute whatever writing is in question. Sometimes it's just a simple signature. Sometimes it's a multi-page letter. It's just basically comparing the 2 documents side by side and seeing if there's features that are in common or features that are not in common, finding the significant similarities and any noted differences. And it's the assessment of the totality of all those features that are either in common or not in common that allows you to render an opinion as to the authorship of that document.
What exactly is a known writing?
Well, with doing a handwriting comparison, obviously you have the document that's in question. The known writing is provided by whatever agency is submitting the case. It can either be a request specimen, which an individual is asked to sit down and provide a sample of their handwriting, or any other documents that are known to be a product of that individual.
In your work for DPS, do you ever sit down with an individual and obtain that known handwriting sample yourself?
We do not. I've only done that one time in my 13 years as an examiner.
So you rely on other people to provide that information to you?
We do.
Did you receive a request to do some analysis in regard to Tammi Smith and Elizabeth Johnson?
Yes.
And approximately when was that?
I have to refer to my report. The report was issued January 28th of 2010, so early 2010.
And before we get to the bulk of that, let me ask you, have you ever testified regarding your work as a document examiner before?
I have.
Have you testified in Superior Court, Maricopa County?
Yes.
Approximately how many times have you testified?
Approximately 50.
In regard to Tammi Smith and Elizabeth Johnson, have you ever met Elizabeth Johnson?
I have not.
Have you ever met Tammi Smith?
No.
So if you were asked to compare handwriting samples from them, you didn't see either one of them make those writings?
I did not.
How do you usually obtain handwriting samples to compare from the agencies? Physically, how does that work?
Well, all of of our evidence is actually submitted through our property evidence unit at our facility. This was a Tempe PD case, so Tempe actually has a procedure in which they take their evidence that needs to be examined at our laboratory. They fill out a request for examination form, and then that evidence gets submitted to us. And then we just simply go down to our property evidence unit, pull the evidence that needs to be examined, and then eventually that evidence gets returned to whatever agency submitted it.
When you obtain the evidence and review it, do you do any kind of notification on the document itself to indicate you've looked at it?
Yes.
What is that?
All the evidence that we look at, we put the item number that it's associated with it, my initials, and in most instances we'll also apply the DPS case number that's associated with that evidence on the document itself.
And when you say item number, whose item number are you referring to?
Whoever the submitting agency is will associate an item number with that particular document.
So, for instance, if Tempe PD has a certain item number they attribute to a document, that's the item number you refer to?
That's correct.
In the case involving Elizabeth Johnson and Tammi Smith, do you recall receiving some items from the Tempe Police Department?
Yes.
Do you recall whether or not they were hand-delivered or they got to you some other way?
I don't recall off the top of my head. I could refer to my notes to be sure.
Go ahead and refer to your notes and just let us know when your recollections refresh.
Okay.
And do you recall?
I do.
If I may, will we approach briefly?
You may. Equipment now, being able to turn things on. Okay, Ms. Andrews, go ahead.
Mr. Kreitle, do you have some documents there in front of you?
I do.
What is it that you have there in front of you?
These are simply the request for examination forms that the submitting agencies fill out when they have a forensic examination that needs to be performed.
Do you also have copies of your notes and your report in this case?
I do.
I'm going to ask you, if you need to refer to that, please let us know you need to refer to that to refresh your recollection. But I'm going to ask you not to testify from it. Just let us know if you need to refer to it, okay?
Okay.
Thank you. Your Honor, may I approach the witness?
You may.
I'd like to see what is being shown to us. Absolutely.
I want to show you what's been marked as exhibit number 41. Do you recognize that document?
I do.
How do you recognize it from the outside appearance?
It has my initials and the date that I resealed the envelope when I was done with my examination.
And is it customary for you to reseal evidence after you've looked at it?
Yes,
And you indicated it has your initials on it?
it does.
And does it also have a date?
Yes.
And what's that date?
February 1st of 2010.
And that's when you finished looking at that document?
It's the day that I returned it to our property evidence unit, yes.
Can you take a look at exhibit number 61 that's in front of you? Do you recognize anything from the outside of that document?
I do.
And what do you recognize?
Again, it has my initials and the date of February 1st, 2010.
And if you could take a look at exhibit number 63 as well. Do you recognize the outside of that document?
I do.
And what do you recognize on that document?
My initials and handwritten date of February 1st, 2010.
Now, if you could take a look inside exhibit number 41 and tell us if you recognize what's inside there.
Your Honor, now's the time I think I need to make a record.
Do you have an objection?
I do have an objection. I'm going to object to these on foundation, the same grounds that I objected to the last witness that they had. That we had quite
quite a bit of discussion on. I thought maybe we might want to do that now.
Well, we're talking about Exhibit 41.
As to all of them.
Okay. Well, you're objecting foundationally to 41. What's the basis of your foundational objection?
It'd take a little bit of time. I thought maybe if we could do it without the jury, we can do it here if you want me to, but I prefer to do it.
It's something that we probably ought to do ahead of time instead of now. And so we don't have the jury coming and going. We don't want to do that. Why don't we do this? Since we may be talking for a little bit, why don't we take a little bit early our afternoon break so we don't waste the time of the jury. So we're going to take a break. It may be a little bit longer since we need to talk a little bit. So assume 10 till 3, so 2:50 that we'll come back, and hopefully it'll be around 2:50. Until then, remember the admonition, and we'll see you around 2:50.
All right.
Okay, please be seated, everyone. We are outside the presence of the jury. Exhibit 63 is already in, and isn't Exhibit 41 in?
Yes, Your Honor. I didn't move to admit exhibit number 61 yet, with the intention of laying the foundation with a later witness.
Judge, if I may.
Go ahead.
This is why the original objection on relevance on these. If I may voir dire the witness briefly, Judge, then I'll explain it.
You may.
I think it's going to go over some ground they covered this way. Did you personally see any of these documents written?
I did not.
Okay. Did you personally see any of these documents obtained?
No.
Did you personally hear anybody say, I wrote this document?
No.
Okay. So you never heard Ms. Smith say anything about any of the documents that are in your possession?
No.
Up there on the stand?
No.
Okay. Judge, if I may, I think we know where the state's going on this. Certainly we do. But they have to provide the proper foundation on these documents to say where they came from, why they think that Tammy, what I think they're going to say is that he's got a sample, a known sample, and that Tammi Smith wrote this known sample. Okay. We have not gotten to that on any of these documents. They found it in a search warrant. There's more than one person that lives in that home. We don't know how many neighbors and friends visit. We don't know why that document's relevant. And that would be my argument as to why it shouldn't have come in the first place.
Hang on for 1 second. Let's talk about what 41 and 63 are exactly. 41 is
Court papers, Your Honor.
court papers, okay, with a signature on them, and those court papers are relating to Elizabeth Johnson's signature?
Your Honor, I think I can streamline things a little bit.
Okay.
We don't intend to have Mr. Kreitle testify that any of the handwriting belongs to Tammi Smith. He's going to testify that he compared one item with another item and the handwriting matches. That's all.
Judge, and I think that two things. I think, one, that they need to show that this is even relevant to get to the point where they're going to use him as an expert and as a witness in this case. And they haven't done that. But setting that aside, if the court disagrees with me on that, my next step is then refer to the documents in generic terms. Not where they came from, not who's on it, no mention of Tammi Smith at all. Because I don't think they can do that, because then the jury doesn't understand the way this works, and they're going to hear Tammy, 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 Tammy.
And hold on for a second, based on the way you say you're going to use it, that might be a valid request, because you're simply using it to say the writer on Exhibit 41 is the writer on Exhibit 61, I think, and perhaps other comparisons. If you're doing that and it's for the limited purpose, then I think it's well taken that we don't get into here's where it's from. Now, I will tell you that her doing that's probably as a result of making sure she lays the appropriate foundation to survive an objection. I understand why you were doing it. And so to some degree, you're asking for it to have it both ways. But from here on forward, now that I understand the context in which you're introducing it, and we've had this discussion, I am comfortable with a reference only to this is document 41, and that these are known basically generically talking about where the documents are from. So I think that's, I will permit that. In terms of relevance, I think they're going to be able to get there. I mean, we can talk about where it's going to lead. Why don't you go ahead for the record so I can deal directly with the relevance objection, how the state plans on utilizing these. I think I know, but let me hear it from you, Ms. Andrews.
Well, right. First of all, Your Honor, if you recall, Detective Galbraith just testified that the item, I believe it was 61, was obtained in the search warrant at the Smith's home. We intend to establish, based on testimony from other detectives who will be testifying in the future, how we can establish that that in fact belonged to Tammi Smith as opposed to somebody else, and we'll be laying that foundation. Additionally, Your Honor, Detective Ramirez confronted Tammi Smith with the handwriting analysis in this case, and Tammi Smith admitted to the police at that time that she in fact wrote what was on the document that is purported to be her writing based on the handwriting analysis.
Judge, if I may, far be it from me to tell the state how to run their case, but why not put this witness on after we've had all these other people? I mean, this is putting the horse before the cart, or the cart before the horse. It's just not the right time for this.
Well, I'm now hearing you say also you want to get into the analysis of where the document came from, that is, who wrote it. I thought I heard a moment ago that all you want to do is say the author's the same.
Not with this witness, Your Honor. Later on, when the detective testifies, she'll present information. And this goes back to the horse before the cart. We can't call any witness without it interloping with something else that happened in this case. It's impossible unless you wanted us to call, well, I won't say you, Your Honor, unless the defense expects us to call a witness and ask them about this piece of information and then bring another witness to talk about that piece of information, then bring back that same witness. Because the detectives did different things in this case. They can't come in and talk about it piecemeal.
I understand the practical considerations. Let's talk about what we're going to do with this witness. With this witness, I think we limit, for the time being, the discussion of what's in 41 and 61, refer to it generically, and he can testify, presumably, that the handwriting on 41 matches 61 without talking about what is in it and who authored it. Then you can go back with whether it's Detective Ramirez or who else, if you can lay the proper foundation that it's Tammi Smith and make that argument. We've already kind of introduced that concept to the jury, but that being said, let's for right now, with this witness, generically talk about the documents and the comparison, and instead of saying what it is, we can talk about his comparison with the documents. Does that solve the issue that you've got for now?
Yes, for now, Judge, I think that does solve the issue. As long as I don't hear the words Tammi Smith or Elizabeth Johnson, I guess. And I don't care about Elizabeth Johnson, because that all he wants, but I don't hear the words Tammi Smith, and, that's fine.
I think you're going to hear it eventually, but for right now with this witness, we're not going to hear it. So I'm fine with that. All right, so we have an understanding what we're doing with this witness as to 41 and 61.
Right, Your Honor, it's 41, 61, and 63. 63 is actually the document he compared to 61.
Okay, 63 is not in, but you can still elicit testimony that 63, the author of 63 is the same as 61 and 41. We're not admitting it yet. I will note that the previous detective had an issue with the foundation as to one of the documents in 63. 63's got multiple documents.
Your Honor, I'm sorry, it's 63 that's admitted and 61 that's not.
Okay, I take it back. 61 is the issue that I've got. 61 had multiple documents. Detective Galbraith did not agree that she was in the presence of Ms. Smith when she got it. That particular document, if you had moved to admit, I wouldn't have let it in. The other ones, potentially, although I'd have to take a look at it. But you haven't moved for their admission. I still think it's okay, with respect to 61, that you ask if the comparison of 61 is the same as 41, that is the author or the handwriting sample. And again, we're not going to talk about what's in it. I'm not going to admit 61 yet, because you don't have the foundation.
Just so we don't go, okay, that's all. You just answered my question. So I mean, if it's asked to be admitted with this witness, I'm going to object.
So you're going to be successful, and I don't think she's going to move to admit it.
I was not intending to, Your Honor.
Okay. All right. Anything else before we take our break, and then we'll bring the jury back in at about 10 till or so? Okay. What I would like to happen, and we can do this off the record. what I'd like to have. Thank you, everyone. Please be seated. We are back. Let the record reflect the presence of the jury panel, Ms. Smith and counsel. Welcome back, everyone. We left off, I think there was an objection, but we're going to ask another question going forward of Mr. Kreitle. So, Ms. Andrews, go ahead.
Actually, Mr. Kreitle, I want to step back a little bit. If you were trying to compare block writing and you're trying to find out maybe who wrote block writing, is it possible to use cursive writing to compare?
No.
And why is that?
Well, cursive writing and any printed style writing are just executed in a totally different fashion. So those two styles of writings aren't useful in trying to determine a common authorship between those two styles of writing.
And before we took the break, you had exhibit number 41 in front of you, which has been admitted into evidence. Can you take a look at that?
Okay?
And do you recognize that document?
I do.
And how did you use that document?
I used this document to compare it to another document that was submitted in this case.
Can you take a look at exhibit number 63?
Okay?
And exhibit number 63, is there a document you used in that exhibit?
Yes.
And how did you use that document?
I was asked to compare the writing on this document to the writing on Exhibit 41.
Now, exhibit number 63 was admitted previously under another detective. Did you use everything that's in exhibit number 63 for your comparison?
No, I did not.
Did you mark what you did use?
I did.
How did you mark it?
I marked it with our DPS case number assigned to this case, the item number that was assigned to it, and then my initials.
Your Honor, may I approach the witness?
You may.
Your Honor, at this time, for defense counsels and my discussion on the break, I'm going to move to publish these. I'm going to show them to defense counsel first.
Go ahead and show it to me. You may go ahead and publish.
Thank you. Mr. Kreitle, I'm showing you what's in evidence is the document you indicated you looked at, which was in exhibit number 63. And you indicated that you compared this document to the document in exhibit number 41.
That's correct.
When you first looked at this document from exhibit number 63, was there anything that stood out just from your observation of the document itself?
Well, my first observation of this document is that there were clearly two different writers responsible for the handwriting appearing on this document.
And I'm going to show you just the first page of the document from exhibit number 63. And if you could identify on what you see on that frame, is there anywhere where you can identify more than one writer?
Yes.
Can you show us where? Well, let me ask you this, Mr. Kreitle. Have you ever used the touchscreen in this courtroom before?
About 5 minutes ago.
Okay. If you want to try and use that, that would be great. But if you could show us where you see different handwriting on this document.
Okay. May I refer to my notes if I have to go through and tell you every specific item that was executed by one individual versus another?
If you need to refresh your notes, to look at your notes to refresh your recollection, please do so. Just let us know when you're doing that.
Okay. I'm going to be looking at my notes here. Okay, well, the first portion where there's two different writers is a section here where it has the name Elizabeth Joanne Johnson. And then the writing below it where it has the handwritten address and phone number and then even the case number. Those are two different writers. If you'd like, I could go through on this page and try to highlight which portions were written by the same writer that executed Elizabeth Joanne Johnson, if that would be helpful.
The judge's permission, I'll allow you to do that.
You may.
And let me know, Mr. Kreitle, if you need me to move the page.
Okay. Clear what I did here. That's all I can see on the screen for now. Can we move up to, do you want me to do the rest of the document as well?
Well, if you could explain what you've shown there on the document now, and then we'll go from there.
Well, the name Elizabeth Johnson that appears at the top, the name Logan Scott, Elizabeth Joanne Johnson again, and then in the general information, everything but the date of birth. And then in the part 2 of information about respondent, the address. So the address in portion 2 and the date of birth, those are written by a different writer. However, everything else on the page that I've highlighted was written by one individual.
Now, did you compare any of the handwriting that we're looking at right now with the handwriting in exhibit number 41?
I did.
And explain to us a little bit about what you were looking for when you compared that handwriting.
When doing a handwriting comparison, I'm simply looking for handwriting features that tend to stand out to me. After looking at thousands and thousands of writing samples over the course of the last 13 years, you develop a kind of a knowledge base of what features tend to stand out as a deviation from the way most of us are taught to write. So it's just looking for those significant features in the question item and then seeing if those items are present or not present in the other body of writing you're comparing it to. So it's the totality of similarities between two bodies of writing with an absence of any differences that allows you to make a determination if somebody did or did not write this body of writing.
And what specifically did you notice in what you showed us here on this document?
I'll have to refer to my notes to the specific features that I found to be significant. One of the features that was significant was, for an example, in the word store down here, how the RE is connected and the E is actually higher than the R. For the most part, this writing is hand printed. However, some of the characters are actually connected, much like you would in cursive writing. So this is kind of a hybrid between printing and cursive. Also, the formations of the N's, most notably up here in Joanne, where it finishes very high at the top on the last stroke that goes in an upward direction. Also, the I dots. Some of the I dots had a very long vertical stroke for the I dot. I guess one example, it's right down here in, oops, sorry about that, in potential. And then up in Elizabeth as well. Sorry, that's kind of messy.
Let me ask you this. When you prepared your analysis for this case, did you have these documents in front of you?
I did.
Did you make copies?
Yes.
When you had those copies in front of you, did you make any marks on the copies to help you identify what you were looking at?
I do.
I'm going to show you what's been marked as exhibit number 195. recognize that document?
I do.
And what is that?
This is a copy of my report and my notes for this particular case.
And when you say it has your notes, what is it generally indicated in your notes when you do a handwriting analysis?
Well, our notes will always consist of an inventory of the items that were submitted, their description, and then a copy of each item that was submitted. So then I can actually take notes on copies of the documents and make any highlights of the features in there that I found to be significant that would justify my opinion in that particular case. And then also any type of instrumental examination done on the documents. Copies of that is also included within the note packet.
Now, in that exhibit, in this particular case, did you do anything to note the difference between the two different handwritings on the document?
I did.
And what did you do?
On the typed text portions on the document, I highlighted in one color the writing of one individual, and then highlighted with a different color the other portions that were executed by the different writer.
And Mr. Kreitle, I showed you exhibit number 41, and you indicated you compared. What color did you use to indicate the handwriting on exhibit number 41 on your notes?
I used a purple highlighter to highlight the portions that were written by the individual that executed exhibit 41, and I used blue for the other writer.
And does that exhibit also contain a report you wrote in this case?
It does.
And does it contain your conclusions?
Yes.
I'll take the exhibit back. Now, we don't have this in evidence at this time for you to refer to, but if you could tell us, as you're describing what we do have in evidence, what portions you indicated were written by one writer and what portions you indicated were written by another, and indicate what they would be highlighted on your notes, that would help us.
Okay, can I start over here and clear this? So the section, your name, the name of petitioner, name of respondent, and then in the general information, the name, address, county of residence, occupation, the section where it says other, and then in the general information part 2, where it says name, county of residence, date of birth, and then below that there's an occupation. Those are the portions that were written by the person that wrote Exhibit 41.
And Mr. Kreitle, is there anything else that, I'm moving up this document for the record, is there anything else that you can see that you couldn't see before that we haven't talked about yet?
No.
I'm going to show you the second page of the exhibit, and again, this is still exhibit number 63. What can you tell us about what you noticed on the second page?
Again, my first observation is that there were 2 different writers responsible for the writing on this page. The name and the birth date were written by one individual. The case number and the current address were written by a different individual.
And did you compare the writing on the second page with the writing in exhibit number 41?
I did.
And what was your conclusion about the writing on this page?
That the writing where it says name and birth date was executed by the writer of Exhibit 41.
And Mr. Kreitle, I'm showing you what's page number 3 of the document that's in exhibit number 63. Did you compare the handwriting on that page with the handwriting in exhibit number 41?
I did.
Is there anything written on that page that you can see that you would indicate matches the writing on exhibit number 41?
No.
And I'm showing you the fourth page in the document in exhibit number 63. Can you tell us about the writing on that page and how it compares to the writing in exhibit number 41?
Well, again, on this page, the first observation is that there were two different writers responsible for this writing. And the portion under summary of any court order, where it starts off with the word asking and ending in the word submitted, that writing was executed by the individual that filled out Exhibit 41.
And Mr. Kreitle, just for the record, I'm going to go ahead and have you read the whole sentence that you indicate was compared with the writing on exhibit number 41.
Asking Logan McQueary and Craig Cherry to submit to a paternity test and random drug testing when the father is submitted.
And I'm going to show you the rest of the page. And I apologize, the Zoom doesn't zoom out anymore so that we can see the whole thing. Is there any other writing on this page that you attributed to being written by the same writer as exhibit number 41?
No.
I'm going to show you the fifth page on this document. Is there any writing on there that you can see that you attributed to being written by the same writer as exhibit number 41?
No.
And then the last page of the document, is there any writing on this page that you attributed to being written by the same writer as exhibit number 41?
No.
And Mr. Kreitle, I'm going to show you exhibit number 41. You talked a little bit about some of what you were looking for on the document. Can you tell us a little bit of what you were looking for on this page that you compared to the document that was in 63? And for the record, this is the first page of the two-page document in exhibit 41.
Again, I was just looking for features that were in common between the writing that we previously spoke about and the writing on this particular page. So the features that I described earlier, such as the RE connected combination, like in the word here, sorry about that, down there, some of the ends in which it finishes much higher than the initial stroke of the N, and then the very large vertical I dots, like in the word did, and even up here in the word is. Sorry, that looks terrible.
Yeah, are there any other features that you noted that we haven't talked about already?
No.
And I'm going to show you page 2 of that same document. Are those the, maybe if you could erase there. Are these some of the same features you were looking at on page 2 as well?
Yes.
And when you did your analysis, did you have a copy of this document as well? Exhibit number 41?
Yes. I actually have the originals of those documents for the examination, but yes, I keep copies in my notes.
And on your copies, did you make any markings to identify certain features?
I did.
When you made those markings, did you make those in red pen?
Yes, the similarities between those two bodies of writing will be marked with a red pen.
I have no further questions. Judge, do you want me to put these back together?
Why don't we put them back together while he's there before we start cross-examination? Okay, cross-examination, Mr. Lee.
What's your title at DPS?
My official title is a Criminalist 4, assigned to the Question Document Unit.
So Criminalist 4 assigned to the what?
Question Document Unit?
Criminalist 4 assigned to the Question Document Unit. Now, you said you had a bachelor's degree in, what was it, forensic science?
That's correct.
Okay. And when did you get that?
Pardon me?
When did you get that degree?
I completed my degree in 1993.
Well, 1993, you completed your degree. What other degrees do you have?
That's it.
Okay, so you just have that degree. And you talked a little bit about forensic document examination and why you're a forensic document examiner, right?
Correct.
Indirect. And you got that, not in college, but later, correct?
Yes.
Okay. And you got that through an apprenticeship, correct?
Yes.
Okay. And you studied under your apprentice at the Department of Public Safety, correct?
Yes.
Okay. Now, so you learned a trade after college, correct?
Yes.
Okay. Kind of like a blacksmith, correct?
Sure.
Okay. And there are outside organizations that give out certifications in this field, correct?
Yes.
Okay. What are some of those outside organizations?
Well, the only certifying body that I feel would be legitimate is the American Board of Forensic Document Examiners.
Okay. What other certifying bodies are there?
For forensic document examination,
Yes.
I believe there are others that nobody that I consider a colleague are certified by. I believe there's the AFDE. Off the top of my head, I don't know what that stands for, but the American Board of Forensic Document Examiners is really the only truly recognized certifying body.
The American Board of Forensic Document
Examiners.
Okay, the American Board of Forensic Document Examiners. Okay, when did you get certified with them?
I actually just started the process with them. In order to do casework at my laboratory, we have to go through a very similar process of completing practical exams.
Let's try. When did you get certified with them?
I am not currently certified with them.
Okay, how long have you been doing this?
13 years.
So in 13 years, you have not been certified with them, correct?
Not by ABFDE, no.
How many times have you taken their test?
I have not taken their test.
Okay. How many times have you applied to take their test?
I just applied a couple months ago.
So a couple of months ago, you applied to take their test, and in 13 years, it never occurred to you that you needed to get their certification.
It's not necessary to do the work that I do at DPS. It's just a process that I'd like to go through now because somewhere down the road, it may be a requirement in our field.
You're not certified in what you do, correct? From a national board.
I'm not certified by ABFDE. I'm certified to do casework by my laboratory.
You are not certified by a national board.
No.
Okay. Now, let's say that you take a look at a document. Okay, let's say it's a large document or a small document, correct? Sometimes you get big ones, and sometimes you get. Well, let me rephrase this, make it a little more understandable. Sometimes you get two samples generally, correct?
What do you mean by two samples?
You have a sample that they want you to. You have a known sample, or at least a purported known sample, and then a sample that they want you to either exclude it or include it as to being written by the same person as the known sample, correct?
Yes.
Okay. Now, how much does a person have to write in the known sample before you can say, oh, I can compare it to the unknown sample?
There's no hard, fast rule for a certain amount, but more than a sentence or two.
Okay. So there's no hard, fast rule, correct?
No.
Okay, now the one you're comparing it to, how much writing has to be there?
Again, there's no set required amount. If it's simply a handwritten phone number or maybe a few hand-printed characters, that typically would not be enough writing to be identified to a specific individual.
Okay. So let's say in your field, okay, what treatise is there that says how much you should have to have written before you can say, definitely I've made identification?
There is no specific treatise.
What scientific study is there that says that you have to have a certain amount before you can identify or exclude?
There's no study that talks about a specific amount of similarities between two bodies of writing that are required before you render an opinion.
What study is there that looks at the testing of known documents to find an error rate in your field?
There have been a few individuals that have done some testing between document examiners and lay people.
Okay. And so you've read those. How much do you need?
Again, there's no set amount that's per se that's required to do a suitable comparison.
So in your field, there's no set rule on how much there has to be written, correct?
No.
And it's completely up to the person who's analyzing the document, correct?
Yes.
Okay. Let's talk about statistical data. What statistical data is there to talk about the error rate that forensic handwriting analysis make or don't make?
There's very little statistical data out there. The one test that was done, I don't know these stats off the top of my head. I have to refresh my memory on the papers that were written. One test that was done there was a 6%, I believe, error rate in that particular study.
Okay. And again, in that study, what was the writing sample? How large was it? What did they have to compare it to? They have a large amount or a small amount?
I do not know.
You don't know. Okay. What was the sample like? How many people, how many document examiners did they test in that particular study?
Again, I don't know off the top of my head.
Okay. Now, let's talk about, you talked about deviation from the norm. I remember that phrase. You said that, right?
Yes.
Okay. What do you mean by deviation from the norm?
Well, deviation from the copybook style that most people are taught to write.
Okay, now, what copybook do you use for reference?
There's not one set rule. There's a variety of copybook text that most people in this country were taught to write at an early age. One of them is the Palmer method. When you start being taught how to write, you're taught to form those letters in that particular way. And then as you mature as a writer, you come up with your own writing habits for a variety of reasons.
Okay, let me ask you. There's a number of ways when little kids, I remember going to school and I hated it. And I hated it because I had bad handwriting, and I spent 12 years of people telling me I had bad handwriting. So, let's just say, for example, Ms. Smith, what style was she taught from?
I do not know.
Okay. Are you aware of anybody knows what style she was taught from?
I do not know.
So, there's a variety of books, and they have the standard, and different schools in different areas of the country teach from different standards, correct?
Yes.
Okay. So the norm, the deviation from the norm would come specifically from the standard that person was taught from, correct?
I would think so.
And in this case, we don't know what anybody, in particular, Mrs. Smith, we don't know what norm she was taught from, correct?
That's correct.
Now, you work down in the forensic lab?
Yes.
Okay. You work with a lot of those guys down there? You know them in the hallway?
Sure.
People outside your department?
Sure.
Okay. You know they test DNA down there, right?
Yes.
Okay. How many alleles are there that they test for? You know?
I'm not in that unit. I don't know.
Well, have you seen the numbers on DNA and the statistics on DNA?
I have.
They're astronomical, correct?
Yes.
So if they get a match on DNA, since you don't know how many alleles there are, we'll leave it at that. When they get a match, it's in the quadrillions. They would have to be somebody else. 1 in 9 quadrillion that it's not this person, correct?
I believe so.
Okay. Now, in your field, what's the standard on the number of deviations from the norm that you have to have before you make an identification?
There is no set statistical requirements. There's no standard deviation.
So there's no standard. It's a subjective thing, correct?
Yes, a handwriting examination is a subjective type of comparison.
Now, by subjective, we mean personal, correct?
I don't know if I'd use the word personal. It just means that it's based on your training experience. It's not based on instrumental data or any kind of statistical foundation.
Subjective to you and your trade, correct?
That's correct.
Now, how many deviations from the norm did you find on the 2 works that you talked about? Well, how many features did you find? Did you find 1? Did you find 2?
I didn't count how many features I found in common.
So you don't know how many features you found, correct?
No, it's not part of my routine to count how many similarities there were. My job is to look at the bodies of writing, highlight the features that are in common that I find to be significant, with an absence of any significant differences, and using the totality of all of those observations to render an opinion.
Needless to say, you don't know how many features there were.
No.
Now, I was sitting over here, and I was listening to you, sitting over here by Mrs. Smith and by co-counsel, Ms. Phillips. And I was thinking, for some reason I thought, well, I'm going to go to my bag. Because I looked at the writing that you had up there on the screen. It's easier to see in person, I guess, than it is on an overhead projector. But something came to my mind is that people write differently at different times, correct? Under different circumstances. Stress. They write quicker, correct? Or maybe harder.
That's possible.
So somebody could press down harder on the page under stress, correct?
That's possible.
Or somebody could write quicker under stress, or even slower under stress, correct?
It's possible.
Okay. And so I thought that's going to be reflected in somebody's writing, correct?
It could be.
Okay. And I also took these out of my little bag. Got a pen here. This is a ballpoint pen. That has a distinctive writing to it, doesn't it?
What do you mean by
blue?
Okay.
May I approach your witness? You may. All right. Fair to say probably a blue ink ballpoint pen?
Probably.
Large? You can get a good grip on that thing?
It's a normal pen, yes.
Yeah. Now, let me approach the witness again. I'm going to show him what appears to me to be a pencil, number 2. Used a lot of these. What's that?
An Office Depot pencil.
An Office Depot pencil. Now, when you write, and even a layperson can see, when you write with a pencil and that pen, they're going to be able to see, hey, there's a difference, correct? Even if the same person wrote it.
Sure, there's a visible difference between the way these 2 instruments write.
It affects the writing, correct?
I don't know if it affects the writing. It makes them look different.
Yeah, it does. May I approach the witness one more time? You may. Wouldn't touch the end of this. All right. What is that I've just showed you?
And that appears to be a Sharpie black permanent marker.
Sharpie black permanent marker. And that definitely changes the characteristics of the writing, correct?
It can.
Yeah. Now, all of those things, stress, writing instruments, I'll change the characteristics of the writing, correct? Even a lay person can see that.
I wouldn't say it would necessarily change the characteristics of the writing. Obviously, a writing instrument's going to make the writing appear to be different in appearance, meaning color or size, but it's not necessarily going to change the characteristics of the way the writing is executed.
Now, why do... You said you investigated forgeries, right?
I don't investigate forgeries.
Well, you look at documents that other agencies think might be forged.
That's correct.
And let's use our common sense here. Let's take a check. Somebody might want to forge a check because they want money, right?
Sure.
Okay. Now, let's say that the bank has a signature on the file. Some do. And a forger might want to copy someone's signature, correct?
Sure.
Now, when they're copying somebody's signature or writing style, what are they trying to do? Make it look like what?
Or they're trying to make it look pictorially similar to whatever signature they're trying to forge.
Now, I'm just going to take a wild leap here. Is it fair to say that when I've got a lot of time and I can go slowly, my forgery is better than when I'm going really fast?
Not necessarily. There's two ways to forge someone's signature. You can either try to make it look pictorially similar, which will require you to write at a slow speed, which will obviously look very poor. Or you can try to maintain a speed that would appear to be genuine, but then you will not mimic some of the writing characteristics in that signature.
Okay. Now, there's some pretty good forgers out there over the years, right?
I suppose there have been.
There's been some notorious forgers over the years, correct?
Yes.
Some pretty good forgers over the years out there. Okay. So people can't do it.
I believe those forgers were eventually caught.
People can.
There are some people that do a very good job at mimicking someone else's writing style. That's correct.
Okay. Now, you did not see anyone write any of the documents that you analyzed, correct?
I did not.
You don't know the speed at which those documents were written, correct?
No.
Okay. You don't have the instrument that those documents were written with, correct?
I do not.
Okay. You don't know the emotional state of anybody who wrote those documents, correct?
I do not.
You don't know whether those... Let's take the court document that we talked about. Now, you don't know when that was written, correct? Because you didn't see it.
No, I don't know the exact date it was executed.
You don't know whether it was written... Parts were written one day and parts were written another day, correct?
That's possible.
You don't know that parts of it were written with one writing instrument and parts of it were written with another writing instrument, correct?
Well, I do know that.
Okay, so were there different writing instruments?
There were.
Okay, how many?
At least two.
Okay, at least two different writing instruments. Okay. You don't know what day or what time those were put down on paper, correct?
I do not.
Now, there's nothing that you've testified to regarding the authorship of this. Well, let me rephrase that. You did not see nor observe directly anything being put down on paper, correct?
That's correct.
No further questions, Your Honor.
Thank you. Redirect, Ms.
Can I
Andrews.
approach the witness and grab my pens?
You may get them back. Ms. Andrews.
Mr. Kreitle, the defense counsel asked you about stress affecting a person's writing. Does stress affect a person's writing?
It can, to some extent.
And he asked you about different writing utensils. Does that affect the characteristics you're looking for in comparing writing?
It can. The most obvious is just the appearance of the line on the page and the color.
Now, he asked you a lot of questions about differences in writing and people forging documents. For instance, somebody trying to pretend they were someone else by the writing. We would call those questions?
Yes.
Now, would you consider his questions relevant in a case where you couldn't match the writing?
Finish the question before you state the objection. Don't cut her off in mid-sentence. Go ahead.
In this let me actually rephrase the question. In this particular case, I believe you testified that the writing in Exhibit 41 matches the document in Exhibit number 63.
Yes.
You didn't find that they don't match.
That's correct.
If there were stressors or other issues that would affect the writing from one day to the next, would that have made it more difficult to match those writings?
That's hard to say. Not sure I quite understand the question. I didn't notice anything on those documents where some portions were either distorted in some way, meaning either being disguised or forged.
Well, let me ask you this. Defense counsel was asking you a lot of questions about the difference in handwriting perhaps from one day to the next. Would that be relevant to determining whether they matched or the fact that they didn't match?
The writing on the documents matched. Whether or not one was executed one day and some of it was executed the next did not affect the ultimate determination of who executed the writing.
Now, if you had a case where a police department gave you two different writings and they told you, we know for a fact these two match because the person told us they were written by the same person, and you looked at them and determined that you couldn't match the characteristics, would these issues that defense counsel brought up be of concern to you?
Which issues?
The issues that would affect the characteristics in writing.
No. I mean, the examination we do between two documents is independent of any other information we're given.
And does speed affect the characteristics that you're looking to, speed of the writing? Do they affect the characteristics that you're looking for when you're comparing writing?
Yes, well, speed is one factor that's given or considered.
And in this case, did you determine any issues that you felt were attributed to difference in speed in writing these two items that you compared?
I didn't feel there were any significant differences in the speed at which the writing was executed.
And what about how hard the writings were pressed down when they were written? Did you have any concerns about whether or not there were issues in how hard they were written?
No.
Defense counsel asked you about certification by the American Board of Forensic Document Examiners, and you stated you don't have that certification.
I do not.
You were cut off a couple of times when you tried to talk about the certification you do have. Why don't you tell us about that?
Well, in order to do casework at the laboratory that I'm employed by, you have to complete a 2-year training process, a series of practical exams, proficiency tests, a handwritten test. It's extremely similar to the whole outside certifying body that ABFD provides. It's something I'm choosing to go through now simply because it may be a requirement in the future, and I just want to get ahead of the game. It's something that certainly can't hurt you, but it's certainly not required by our laboratory because they put us through the same type of rigorous testing.
And in this case, were your conclusions examined by anybody else?
Yes, all of our cases are peer-reviewed by another examiner at the laboratory.
Explain to us what peer review is.
Well, our laboratory has a 100% peer review requirement, meaning any case that's done in our unit has to be reviewed by a fellow examiner by looking through your notes and looking at the features you looked at to either agree or disagree with our findings. So a report is not released until 2 examiners agree on the results.
And in this case, that was done?
Yes.
Who was the other examiner who reviewed your results?
Robert Stevenson.
Thank you. I have no further questions.
Thank Thank you. Did the jury have any questions for Mr. Kreitle before we let him go? Going once, going twice. May this witness be excused. Ms. Andrews?
Yes, Your Honor.
Mr. Lee? Yes, Judge. You may sit down. Thank you.